Magistrate for Code Enforcement, and we are here for the October 20th hearings. We have a very short agenda today, and we really can't even approve minutes.
Why not? Well, if you approve them.
All right, well, I've read the minutes. Is there any objection to approving the minutes? Hearing no objection, we will approve the minutes. Moving to the initial hearing that is set for today, it is property owners David Campbell and Marjorie Yap Howe, street address 3226 South Atlantic Avenue in Daytona Beach Shores, Florida. Code enforcement case CDEF 2021-30. Ms. Herstein?
Thank you, Your Honor. I am actually not planning on introducing anything into the record this morning other than a motion for continuance, which was received October 13th by new counsel who has been retained by Mr. Campbell. And I'd like to offer you a copy, if I may approach.
Yes, please. I actually have not seen this.
If you'll recall, this particular case was continued to today's hearing from the September 15th hearing, as counsel was out of town and there were a few reasons listed. You granted that continuance, and then based on a local counsel being obtained, this motion for continuance came in based on him, Mr. Latinsky, Attorney Latinsky, having had previous plans to be out of the state. It appears at the bottom of the page 1 for the motion for continuance, it appears to drop off, but that I've seen in other communications to have been from October 18th to October 28th. I have since received, possibly even before this, received confirmation that both Mr. Attorney Latinsky and Mr. Campbell will be present on December 1st. If they worded it, if a hearing is required, and even if the property is compliant, we still do plan to bring the property before the special magistrate. So, but I have, both of them I have received confirmation that they do intend to be available and be present.
And you're saying December 1st because there is no November meeting, correct?
Correct. The end of November and the end of December are very awkward times to hold public hearings and meetings and expect people to be available. So we typically combine that to one early December meeting. And this year that falls on December 1st, Wednesday.
I missed last year because I was in the hospital. Yes, okay. The motion for continuance is granted despite the fact that this was procedurally a gross mishandling of this. We do not entertain motions for continuance in the future by either calling my law office or pestering the staff here in the Code Enforcement Office. In the future, there would have to be arrangements made for someone to call in by Zoom or Teams, whichever we're using currently, because we have done that before with other litigants, and then request a continuance. For the record, this was agreed upon by me and Mr. Latinsky prior to this hearing when he called me on my cell phone while I was driving in the car and did not have the ability to refer to the book to understand that this was a second continuance and that Mr. Latinsky had taken this case 10 days prior, knowing that he would not be available to be here. So going forward, we are not going to be doing it this way.
Thank you, Your Honor. And two clarifications. You mentioned calling in by Zoom and by Teams. We actually no longer have a Zoom account as a city, and we have attempted in this forum to use Microsoft Teams because of the placement and number of our speakers. It is there's a tremendous amount of feedback to the point that people on the other end of the Teams line, remote, have a very hard time hearing what's being said. What we have done successfully and what we told this respondent we could do was that they could be present by phone connection, which we have had much, much better results with. I also have outlined, both for this council and for previous council for this property, ways in which they can get evidence on the record. There are a few different time frames and ways that they can do it, and I have outlaid that. I will outlay that again if it becomes necessary for anybody in the future, but we do try to make it as flexible as possible, though we do, if we're just handed a clump of pages to make copies of and put on the record, we do charge the standard state-approved rate for public records request copies, or actually a little bit less. I believe it's actually less in order to do that. So, but we do have that option available.
Okay, well, certainly to ask for a continuance where there's not going to be any evidence presented, a telephone has been adequate for the last 30 years in the Florida court system. We could probably manage it for as limited the opportunity is that comes before us. Okay.
Thank you, Your Honor. The other clarification I would like to make is, basically, can you affirm or do you wish to affirm that basically no pre-hearing motions, pleadings, requests are heard by His Honor, that they happen?
They happen here in the sunshine on public record, yes.
Thank you, Your Honor. I appreciate that. That makes it easier for me to communicate, I think, to people.
And please discourage people from calling me personally if they happen to be a member of the local bar.
Your Honor, had I known that was a possibility, I would have volunteered. That's something that you have asked. But now that you've said as much, I will feel more free to say that. Yes.
Okay, does that conclude the initial hearing, Jess?
It does, Your Honor.
As far as there are no other hearings, and do you have anything else you'd like to say?
As this is the first meeting of a new fiscal year, it's an opportune time to put on the record a couple of business items. Actually, really just one, a clarification from the Florida statutes, whether or not His Honor approves of a certain method for providing notice. So may I approach with a copy,
sure.
A highlighted copy of 162?
Yes, please. Okay.
This is the most recent copy of Chapter 162, and basically of the Florida statutes. Basically, Section 162.03, there is a line that clarifies that a special magistrate shall have the same status as a code enforcement board under the chapter. And the reason that I say that is because most of the language in the chapter refers to a code enforcement board, but that clarification also means this proceeding with a special magistrate presiding.
Okay.
Chapter 162.06, enforcement procedures. Basically, Section 2, about the middle of the section. At the option of the Code Enforcement Board, notice may additionally be served by publication or posting as provided in Section 162.12. And basically, Section 162.12 is about providing notice to respondents. Section 1 lists 4 ways notice can be singularly provided, options A through D: certified mail, hand delivery, leaving notice at the violator's usual place of residence, or leaving notice with the manager if it's a business. And then Section 2 describes other options, being publication and posting notice on the property as additional methods which can be used. And then with proof that we attempted one of the A through D methods, plus an affidavit of publication or posting for whatever we did, we can demonstrate that the statutory requirements have been met for notice. We actually do a little bit more than is required by this statute. When we post, we provide pictures of the posting in addition to just that affidavit. It doesn't specify, but if there are 3 driveways into the property, I'm posting that in all 3 locations, just so there can be no misunderstanding. And we also send the same notice at that point by first-class mail, as a way, if certified mail was problematic for some reason, a lot of times the certified mail does not return to our office, meaning we hope that they got it. It offers one other possibility for them getting the notice, even though it's not required. Today we're asking that, for the record, you reapprove our code enforcement office using posting and/or publication as is statutorily contemplated.
Yes, that method is reapproved. It sort of dovetails with the language of normal service civil process in the state court system. So yes, it is approved. Since you mentioned that this is a new fiscal year, has the city raised any of its costs and fees that it generally asks to have assessed at the end of a hearing?
No, Your Honor.
Everything else is the same?
Yes, those are always, there's always an affidavit provided. Sometimes they're a little bit different. What we provide is the minimum amount it would have cost for any case. And additionally, if we had 2 addresses that we should have sent it to, then we would up it by that 1 piece of additional certified mail. So it does change from time to time based on mailing costs.
Right. Well, what I meant is, had you raised so much like a handling fee for mailing, or raised the hourly time for the code inspectors, or anything along those lines?
We actually can't charge for those. There have been AGOs in the past specifically pushing aside things that, or identifying things that we should not be passing along to the respondent, staff time being one of them. The only time that we do anything about staff time is if we're bringing to you a request for a reduction. If a large amount of time has been spent, staff time has been spent, processing the case and phone calls and letters, et cetera, an inordinate amount of time, then from just a typical hearing or a typical request that somebody fix some items, we might identify to you that we estimate that we've spent $2,000 additional time, and we request that you not lower the fine below $2,000. Occasionally we'll do that. It's not the same thing as asking for $2,000 worth of administrative fees, but it is something that we might highlight. By the way, this took this took 7 different staff members, including executive, a number of hours to get to this point where they were compliant. And so sometimes we'll point that out, but that doesn't mean that you can't lower it lower than that. It's just a mark that we like to point to if necessary, if it seems like it took a long time.
Okay. All right. Thank you.
Thank you.
Anything else you'd like to put on the record while we're here?
I don't have anything other than the next 2 meeting dates, which we already talked about, December 1st, and then the January meeting is January 19th at 9 a.m.
Okay. Do you have any idea when the February meeting is?
It would be the 3rd February of the month, and if you'll excuse me one moment, I can look at the calendar.
And it's a Wednesday, right?
Yes, Your Honor.
That should be fine.
It would be February 18th at 9 a.m.
Okay. I appreciate that. Thank you. All right. Having no more business, this